Hey everybody, John Skiba here from the Consumer Warrior YouTube channel. And in today's video, I'm going to talk to you about something that's going to sound a little bit strange, but happens so often here in my law practice in Arizona that I thought I would do a video to help give you some guidance. So what I'm going to talk about is default judgments. So if you are sued by a creditor, debt collector, whoever it is, if they file a lawsuit against you and you don't file a written response, the court can enter a default judgment against you. And it's the same as if you went through trial or had summary judgment granted against you. It's a legitimate judgment that they can then garnish your wages with, take money out of your bank account, and even put a lien on your home. Now, you're probably thinking, hey, if someone sued me and I didn't respond to it, I ended up with a default, that you'd be aware of it and fully understand maybe what the consequences of not responding are. But you would be surprised at how many people I meet with here in my law practice in the state of Arizona that have no idea that a lawsuit was filed against them, that a judgment was entered against them, and they don't find out usually until something like wage garnishment or bank levy, or they go to sell their home and they find out that there's a lien against their home. Now, how this happens is because when a debt collector files a lawsuit against you, they are required to serve you with the complaint and the summons. And in most cases, that means they're literally going to come by your house, knock on the door, and hand you a copy of the complaint and the summons. Now, if they can't catch you a home, if you're avoiding service intentionally, or what usually happens is you don't even live there anymore. Most of these debts that are subject to lawsuits, they've been purchased by companies called debt buyers. The debt buyers buy these debts when they get charged off for pennies on the dollar. Often they wait years, 2, 3, sometimes even 4 years before they file a lawsuit. You're not living in the same place where you were before. They try to serve you there. They can't find you there. And so in Arizona, again, where I practice law, the courts will often grant something called an alternative service order. And what this order says is that they don't have to serve you the normal way where they come by and drop off a complaint and summons and put it in your hand so that you have proper notice. What they do is they allow them to mail it to your last known address or to even just tape it to the door of your last known address. The problem with that is, obviously, if you don't live there anymore, you're not going to get actual notice. But the court will count that as proper service. The clock starts ticking for you to file your answer. Obviously, you don't even know about it, and so you don't file a response, a judgment gets entered against you. And here's the other kicker to this whole thing. In the state of Arizona, civil judgments are good for 10 years, and then they can be renewed for an additional 10 years, and that can keep happening for the rest of your life. And most states are that way. The civil judgments, once they're entered, they can be renewed. They're good for sometimes 5 up to 20 years and can often be renewed for subsequent periods of time as well. So the short of it is that these things just don't go away. Recently, I had someone come into my office, again, here in the state of Arizona, and they had a default judgment entered against them more than 16 years ago, and now the creditor was trying to start wage garnishment. They had not been served. They had no idea this was even out there. And now the judgments have been accruing interest for 16 years, and so it's 5 times what it was when the lawsuit was actually initiated. So I want to give you some advice and give you some information related to default judgments and some options you have if you find yourself in that situation where all of a sudden there's a default judgment that's been entered against you, and what can you really do about it? So the first thing you can do is you can fight it. When you fight a default judgment, what I mean by that is particularly in situations like I was talking about where you had no idea that the judgment was even entered against you, you need to be a little bit of a detective here. You got to go back and find out how it is that they actually got the judgment against you. The way you do that is you go down to the courthouse where the judgment was issued, and you get a copy of the file. And here's what you're going to look for. You're going to look for a document called the Affidavit of Service. The Affidavit of Service is the document that the process server or the law office or the plaintiff had to file with the court to say that they served you, that they, under the rules, under the law, gave you proper notice of the lawsuit. And you need to read exactly what it says. Sometimes the Affidavit of Service, they're claiming that they dropped it off and gave it to you in person, but you look at the address and the address is incorrect. Or maybe they say that they left it with a spouse and you're not married, or with a roommate and you didn't have a roommate. Because for service to be proper, they have to leave it at your home where you actually reside, or they can leave it with someone who actually lives with you. And it's got to be a family member, roommate, someone who actually lives there. It can't just be somebody who's there visiting for the evening and happens to answer the door. It can't be a relative staying over for the weekend. It's got to be someone who lives with you full-time, who accepted service on your behalf, or you personally. If you read that affidavit of service and there's any problems with that, if they went to the wrong address, if they didn't serve you correctly, if they served the wrong person, or if there's an alternative service order where they said they could drop it off and mail it or post it, you need to look at the alternative service order and see exactly what the court said they were required to do. And if they didn't take those steps exactly like the court says, any of those things, if they're not correct, you can then file a motion to vacate the default judgment. The motion to vacate default judgment is a document where you're pointing out to the court saying, hey, judge, I didn't get proper notice. They didn't serve me correctly. Or if the judge issued an alternative service order, you can show if they didn't follow that correctly. And it's got to be followed exactly correctly for the service to be valid. And here's the thing. Often when you're trying to get a judgment set aside, there's a time limit for you to be able to do that. Not so if they didn't do service correctly. Essentially, the law says if they didn't take that first step correctly to serve you, then technically that judgment is void because the court never had jurisdiction over you to enter that default judgment. And so the court has to unwind it if you can show that they didn't serve you properly. Now, here's the important thing to understand here. You're not going to be able just to go into the court and say, Judge, they didn't serve me correctly. You got to set this aside. The burden has now shifted to you to prove that they didn't serve you correctly. It's always kind of a tough thing because you're kind of trying to prove a negative at that point to prove that something didn't happen, but there are ways you can do that. One is if they send it to the wrong address, if you didn't live there, maybe if you have an old copy of a lease agreement, if you bought a house and you live somewhere else, if you have utility bills, something that shows that you weren't living where they claim you were at the time that service occurred. You can provide that to the court, and that can be evidence they didn't serve you properly. One time I had a case where the default judgment had been entered. My client came to me and said, there's no way they served me like the affidavit of service said they did because I was in a wedding halfway across the country. And the way that we were able to prove that, airline tickets, and we even used Facebook posts because my client had posted pictures of herself at the wedding several states away that were dated of that specific date of when they actually were alleged to have been served. So those are the types of things you can bring forward to get the judgment set aside. Now, here's an important thing you need to understand. If you get the judgment set aside, that does not mean that the case is over. All it means is that judgment that was entered against you is no longer valid, and now we're back to step one, where they have a lawsuit that they need to serve you. So what it does do, particularly if it's old, like that judgment I was telling you about that was 16 years old, initially it was like a $5,000 judgment. Now it was literally something crazy like $45,000. It unwinds all of that interest, all the penalties, all the attorney's fees, everything that they added onto it. We're back to step one, $5,000 judgment. And then that's an opportunity for you to put forward your defenses or alternatively to negotiate a settlement of some type. Which takes me to our second option if you have a default judgment that's been entered against you, is settlement. Settlement is where you're offering some type of proposal to get the judgment dealt with that's less than what they're saying that the total amount is owed. So if they're saying they have a $10,000 judgment and you go in and you offer $4,500 and they accept it, then the judgment has been settled. That's what we're talking about when we're talking about debt settlement. Now, you may say, well, why don't I just fight it? Well, if you go and get the affidavit of service, or let's say you just know, hey, they served me, I didn't know what to do, couldn't afford an attorney, now I have this default judgment. In those types of situations, you're not going to have the ability to get the judgment set aside. If they legitimately served you and you just didn't respond, then you really need to look at the second option, which again is settlement, where you're trying to negotiate something and get a deal in place. Now, it's important that you act quickly because if they have a garnishment in place, a lot of creditors are not going to negotiate with you because the wage garnishment is already going. If you're asking for a payment plan, they're going to come back and say, we got a payment plan. It's called a wage garnishment. We're going to take your wages. And in Arizona right now, they can take 10% of your wages. You want to try to reach out relatively quickly once you get that and try to negotiate something. Settlements can take a couple forms. You can offer a lump sum settlement, or you can offer a payment plan over time. Now, the lump sum, you can discount it. And I always say, no matter what you offer a creditor, they're going to come back and want something more. So I wouldn't, if you have a specific budget, again, if you have a $10,000 judgment and you know the most you can pay is $6,000, maybe you offer 3 or 4 because you know they're going to counter you in coming back. So settlement is one option to get the judgment resolved. Once you do settle it, there'll be a settlement agreement. Again, you need to follow the rule. Do not pay them any money until you have it in writing that the debt will be settled in full. That'll be completely settled. You don't want them to come back and try to pursue you for an additional balance because that wasn't made clear. But don't pay them anything until you have that in writing. I don't care if it's an email, a letter, whatever it is. Just make sure you have something in writing where they're acknowledging that it's being settled in full before you pay them any money. And then once they do, they will file a document with the court called a satisfaction of judgment. The satisfaction of judgment will let the court know and the rest of the world know that you have paid that debt and it's no longer something that needs to be dealt with. Let's talk about number 3. Let's talk about the nuclear option here. If you can't fight it, if you can't settle it, if you're finding yourself maybe where you have a judgment that's been entered against you and there's a bunch of other debt problems, this is when you may need to look at bankruptcy. Whether it's Chapter 7, which is what most cases are filed under, or Chapter 13, a bankruptcy will do 2 things. The first thing, when you file the initial paperwork with the court, it stops all collections, stops wage garnishments, bank levies. They can't even continue to try to call you, send you the snotty letters. Everything just stops right from the day you file your bankruptcy with the court. And so if you have a default judgment against you and you're worried about the types of things we've been talking about, wage garnishment, bank levy, this is when you need to get the bankruptcy case filed, get that voluntary petition filed with the court. That'll stop all collections against you whatsoever. It also then will eliminate the debt. It discharges unsecured debts, the credit cards, medical bills, personal loans, these judgments, even some of the judgments where they've recorded a lien against your home. In many situations, we can actually get those voided and get the debt thrown out as well. So I always say this, no one wants to file for bankruptcy, but you always have it in your back pocket if you need to. If situations get bad enough that they're making it so it's tough to buy, the basics, housing, groceries, gas to get to work, all that kind of stuff, that's when a bankruptcy can step in, get rid of the debt, stop the collections against you, allow you to move forward. So again, just as a quick recap, if you have a default judgment that's been entered against you, if you're just finding out about this, or whether you've known about it for a while, your options are 1, to fight it, to try to file a motion to vacate or set aside that default judgment, to be able to come in and then negotiate at a much lower amount or put up any defenses you have to it. Second option is just straight settlement, where you're just reaching out to the creditor or their attorney, trying to put a deal in place to get this thing taken care of. And the third option is when you pull the grenade, throw it in, and just blow it all away in a Chapter 7 or Chapter 13 bankruptcy. If you're in the state of Arizona, my information is below. I offer free consultations. I'm happy to talk to you about your case, about different ways that we can deal with these types of issues like wage garnishment, default judgments, bankruptcy, go over everything and determine what's the best plan for you. Thanks for watching today.